Yeah, Tamar, when did the idea come up with a book? I think it was me sending you and to Antonio Manuel España an email. And I remember quite well the situation because I had just reviewed a book proposal for a big publishing house, and it was really a very bad book proposal. And I was thinking, how do people dare to suggest something? And if they dare to do, why shouldn't I also try to do, or why should we also try to do a book which gives really a broad perspective? And then I sent an email to Antonio and to you, and I was absolutely thrilled that within a few hours, both of you responded very enthusiastically, and so it all started.
Yes, and I remember getting these emails and thinking what a great thing it would be to edit a book with Antonio Manuel España and Thomas Duve. I couldn't think of a better team as far as I'm concerned. But then I also remember us having a lot of debates about what this book should be like. How should we organize it? What's really important? What's not? How to make it accessible? How to make coverage? So I also remember a long process of trying to figure out what this book would be like, with Antonio Manuel España sending us all the time information and us trying to catch up with him.
Yeah, that's true. And he, generous as he was, he sent a lot of his ideas, which also then, became part of the book, even if he died before. And we both remember very well, I think, that we met in 2019, in June, in Portugal, in Lisbon, to meet him. He was already ill. And then we couldn't meet him anymore. But we decided, and we asked ourselves on that weekend whether we should continue without him, and thought, well, we continue without him. And so in the end, the book is also a bit dedicated to him, and we explicitly dedicated to him also.
Yeah. So after all these discussions about what kind of book, I think we came up with a formula that I find really interesting. And we thought that one of the things that were needed was actually a narrative about Latin America as a whole. We tend to really care about differences, and we tend to, it's in English you say the God of small differences. And of course there are many very good books about the history of the national law, the other Argentinian, Brazilian, Uruguayan law. But we were wondering whether there is a common Latin American story to tell, even though we are cognizant of differences within Latin America. And I think this is really important to realize, of course, that law is never national because there's always conversation across frontiers from whenever, it's not just now. But at the same time, I think the idea was to ask ourselves how this law develops within the continent, but also with conversation outside the continent, which is the idea of the global perspective. So on the one hand, is there a common story to tell about the development of law in Latin America, but at the same time, which parts of this story are also true for other places, and how the conversation between the development in Latin America and development elsewhere goes on, how Latin America affects other places, but also how other places affected Latin America, to see this kind of mutual relationship. I think for me, this was really an important. So kind of asking ourselves, what is the coverage, I guess, in terms of geography, but the geography is, of course, not very defined because Latin America is not a very well-defined term. And I think, if I remember correctly, we chose it on purpose precisely because it is ill-defined. And we asked each author to build his own or her own Latin America, to take the cases that they seemed spoke to one another, had commonalities, without defining which countries belong to Latin America.
Yeah, there's one more aspect to the global perspective that I remember was important and is important to us. That is somehow to write also a different legal history, or legal history in a different way. In the sense of trying not to apply, Eurocentric concepts on realities which are different, And we have one chapter on what is global legal history, which places huge emphasis on the fact that there are multiple places of production of law, written by Mariana Diaz-Pais. And we wanted to make visible that law obviously is not only state law, and that's part of our methodological idea to overcome in a certain way this state-centered legalist tradition of doing legal history. And I'm very happy that we have some chapters on the history of historiography, very good chapter by Carlos Petit. And I think the idea of presenting legal history in a different way without now falling into a constant aggression against tradition is one thing we all and the authors, I think, tried to do.
I would add to it from the methodological point of view, for me at least, but I think that we ended up all agreeing about that too, was really important that it wouldn't be a typical manual of history of law where you would describe multiple solutions, institutions, but rather it would be a book that would really think about how law developed over time. What is law? Where do you find it? Who makes it? Who uses it? And to show that, in fact, not only specific legal solution have changed over time, but also the whole concept of what is law, what it is supposed to do for us. So I think my feeling is that we wanted to move away from particular solution, which might be arbitrary, accidental, you can trace how they came about, to really the contexts in which they were formed. I sometimes use the image of thinking about it as law as the operating system rather than the Word document, of really thinking what makes a certain solution that might be arbitrary work. How is it made? Who makes it? So really give background information for people who are researching a particular question, place, or period about what is operating in the background that perhaps is not very visual always, and nevertheless is always there. I have this quote I love from Goethe that says that Roman law is like a diving duck. Whether you see it or not, it's always there, which I think he was right. But I would say law is like a diving duck. We might not realize how it makes people do or say certain things, why certain things produce certain results. But that's really how law operates. And I think it was really important to do that too. That's why we could talk about Latin American law from before Europeans invaded until the present in such a short book, and still think it makes sense. So I think this was another methodological input that we wanted to bring forth, and that it would be perhaps useful for both historians and jurists, because historians often center on the specific results, the interests that people have. But of course, as jurists, you always think, so how did they go about trying to get this result? What instruments, what methodologies, what words they used to and thought it will produce the result they want. Whether they were right or not is something else. But also for jurists who tend to think that law has its own, lives in a bubble, right? And to make jurists realize that there's a huge struggle around who says the law, how it is implemented. We often think about economic struggles, political struggles. They're incredibly important. But the power to actually produce something that is normative is amazing, I think.
And I think 10 years ago, it wouldn't have been possible to do that book. Well, definitely I would not have been in the position and to do it. But I think in the last 10 years, we experienced an enormous growth, 10, 15 years or something, in knowledge about legal history of political, social institutions in Latin America. And to my understanding, this is due to a certain convergence between social historians, anthropologists, people coming from cultural studies, more interested in law, and many legal historians opening them for social history, for cultural history, for different perspectives. And so I think one of the ideas behind the book is also that there is a very rich scholarship emerging from different fields, and often they do not communicate so much. So we have the classical legal historical community, which have accumulated a lot of knowledge during the century of research on legal history in Latin America. And they perhaps do not read so much what's written by social historians, and vice versa, the other way around. And I think one of the big opportunities of these times of international communication is that we really have a wealth of methodological reflections and of knowledge we can combine. And a bit, I think the selection of the authors responded also to that. We have people who are doing more social history, some people who are coming from the classical field of legal history. And in the end, I hope this book can also be a way of overcoming these separations between disciplines.
We were thinking about what to study, Latin American law in global perspective, how to study all these methodological questions of what's needed, but we were also engaged with the question of who should study. And I think with who should study, we wanted what you mentioned, the dialogue between different disciplines and really taking advantage of what other people have done and done extremely well, of course, and how we learn from them. But we also wanted the author of this volume to come from different national traditions, because I think both you and I are quite fascinated now with how the way we have been taught, the people we have read, the different national traditions of doing stuff really affect how we go about asking questions, how we go about answering these questions. We're organizing in a few days this conference that it's
conversing with the elders.
With the elders. The idea of the elders are the people, of course, who did research before us, that we're interested in what they're doing, but how do we use what they have done before? How do we converse with the previous scholarship? And we do think that of course, today we have a bit of globalization of knowledge, but there's still very strong nationalist traditions, national traditions in each place. But another thing in that way for us was to involve Latin American scholars in the project, because of course there's very important scholarship that is being done in Latin America, very often in Spanish and Portuguese, so perhaps not read as much as it should be because of the quality. But we also wanted their perspective coming from a different national traditions in this book. So we involved a lot of Latin American scholars, but we also chose the non-Latin American scholars according to how much they engage with the scholarship produced in Latin America. So we chose scholars who might not be Latin American or might not sit in Latin America, but we know constantly converse, perhaps not with their elders, but with their peers, but also with their elders in Latin America, and really integrate the Latin American perspective into their scholarship.
One aspect I'm really happy about, and it's a bit strange that we're speaking so good about our own book or the book we edited together, but one thing which is really, I think, a privilege of gathering such a diverse group of people is that we have a lot of topics which usually you do not find in one book, but which, to my understanding, always are part of Latin American legal history. We have canon law on one hand and chapters on dictatorship. We have human rights and history of constitutions. We have colonial, indigenous law, and we have questions about diversity and legal pluralism. And I think these are all topics which are discussed in the academia very intensely, but usually you do not find them in the usual textbooks or in the books I know, at least, on Latin American legal history. And I think this is also a consequence of the diversity of people coming from different traditions, where, for example, in Brazil, these topics are being discussed intensely, whereas in other areas or countries, they are not discussed in a similar intensity.
Yeah. And we actually, in order to get to this agreement about what we want the book to be. Of course, we met with the scholars writing to this book. We had 2 meetings in which not only we read each other's chapters and gave comments, but we also spoke about the project and what it's supposed to be and why we're writing this book. And we agreed, we discussed. So that was really interesting too. And there are at least 2 themes, I think, that, for example, we agreed that should be in each chapter, regardless of the question, there might be a chapter dedicated to them, which is first the presence of indigenous and Afro-Latin American law, that it's not something that is only in a certain period. It runs through the whole book in all the chapters, the role of indigenous peoples and Afro-Latin Americans in the forming of Latin American law in global perspective, but also religion, because so many books of legal history tend to think about law as a civil and not a religious affair. And in fact, there is your chapter on canon law, but we have tried to show that religion matters throughout. It mattered before Europeans invaded the continent, and of course it matters today too.
Yeah, the book appeared within the series, The Cambridge History of, and I think that's very good because it's a very prestigious series which has reaches large audiences in academia. I'm very happy that it's, I think, the first open access book which is published in the series, so it's available everywhere. And we know that this is very important for Latin American scholars, especially, but also for many European scholars, that they can download it. And we decided to do it in English because simply English has emerged in the last decades to be the lingua franca of communication. But I'm very happy that we have 2 translations already underway to Portuguese and to Spanish. And so the book will be published in Spanish and Portuguese also. And I think there are also some Chinese scholars interested in translating it. So the idea is to make the book available to many people.
Mm-hmm. And I think, honestly, I know that one can criticize choosing English perhaps again as the language of communication. But part of what I felt was really important is precisely to bring scholarship that is usually in Spanish and Portuguese to a larger audience, because it was very important for us, of course, that it will be available in Spanish and Portuguese, but to have perhaps people who don't speak Spanish and Portuguese realize the important contribution of scholars who write in Spanish and Portuguese was really, really important. So in that way, it was not only does a wider audience can read it in English, but also it's making available really important scholarship to the attention of people who don't read Spanish and Portuguese. So, but of course we did want a Spanish and Portuguese edition because this is the major language spoken in Latin America. So it was important that it would be available for Latin American scholars. So I think, like with the global perspective, I have the feeling that we are helping bridge linguistics. So if you want to bridge disciplinary, if you want to bridge national traditions, we also wanted to bridge the language barriers that are still very strong. When I look at what my colleagues are reading, my colleagues in the US read English mostly, unless they're specialized in a particular country and then they know the language of this country. So it was important to kind of translate the scholarship that is happening elsewhere into English, at least for me.
It's not like a textbook where you can look at the index and find information about the civil code from 1850 or something, but to give a narrative, to take the readers to understand what the legal history is about, and that this has to do also with the second aspect, which I think is important to us, is that we also try to show that law is constantly changing, and that it's evolving, and that it's not something stable, and to analyze also some of the mechanisms which are operating in the background. And the third keyword of the book, in a certain way, could be the multiplicity of actors and also multiplicity of normative orders. Because if we always have a state-centered approach to law and legal history, obviously we will focus on a certain set of institutions, basically as actors. If we have a more open or broad concept of law, we will have to look at different sources, different actors, and different spheres of normativity. And I think this is also one important characteristic of the book.
Of course, besides narrative, plurality of actors, and change over time, the perhaps most obvious keywords would be law, global perspective, Latin America, because I think we have already spoken about what they mean, but they were all very meaningful for us as a way to think about this project. And as I mentioned before, though it's an edited book, we really feel that it's a common project. It's not a collection of articles or chapters that have nothing to do with one another. We really tried to have a kind of a working group in which we were thinking about these terms, we were thinking about what we should be doing, and I think we did it together. So I think for all of us, the law, global perspective, Latin America was really important as well.
Yeah.